Hello, this is the second in 3 videos about privity, and I want to talk now about what the rule is and what its scope is. The source of the rule you find in your textbook at chapter 11, paragraph 10, and is described really well in the case of Coulls and Bagot. We've discussed this case when we looked at consideration. This is a case where Mr. Coulls entered into a contract to allow O'Neill Constructions to quarry part of his land. In exchange, O'Neill was required to pay royalties to Mr. Coulls and his wife, who were joint tenants. Then Mr. Coulls died, and the executor, Bagot, sought to determine whether or not O'Neill was required to pay the royalties to the estate or to Mrs. Coulls. Ultimately, this went to the High Court, and a majority of the High Court held that the royalties were payable only to the estate, on the grounds that Mrs. Coulls wasn't a party to the contract. In discussing the issue of consideration, a majority of the judges, who concurred with Chief Justice Barwick, concluded that where a promise is made to joint promisees, then either promisee can enforce, even though the consideration only moved from one. Ultimately, Mrs. Coulls took her interest as a beneficiary under the will, so don't worry about her too much. But what is really important here is that because she wasn't a party to the contract as such, she could not receive the benefit of the contract. The doctrine of privity of contract applies only to contractual rights and obligations. If the contract involved gives rise to non-contractual rights and obligations, then it's possible for these to be enforced against or in favour of those who are not parties to the contract. It's important to remember in this context that there's nothing to prevent a contract for creating benefits or rights for third parties, for people who aren't parties to the contracts. But the privity rule prevents those third parties from enforcing those rights. A lot of the time, these kind of issues come up in the context of insurance. And the next case we want to talk about, Trident General Insurance Company and McNiece, is a really good example of that. Once again, this is a case that's come up in the context of consideration, and you'll find more information about the case in the consideration chapter of your textbook. In this case, the High Court cast some doubt upon the extent to which the doctrine of privity is relevant in modern Australian contract law. 2 of the judges said that the doctrine of privity of contract produces injustice, where third parties are intended to benefit from the contract and cannot enforce it directly. You'll remember, just a second ago we were talking about Coulls and Bagot, and in that case the dissenting judges, Barwick and Windia, believed that the only reason that Mrs. Coulls could sign, or the only reason for her signature, would be to demonstrate that she was intended to be a party to the contract, and that she should have succeeded on that point alone. But that was obiter, and it was a dissenting judgment. A useful dissenting judgment, but dissenting judgment nonetheless. These judges said that it was time to review the laws. They allowed the intended beneficiaries in that particular case by looking at the commercial reality and deciding that it would have been inequitable for an insurance company to turn their back on the risk. The problems that they highlighted included often damages are not suffered by the contracting party. If one party breaches a contract, another party might have suffered no damages, or the party to the contract might have suffered no damages compared to their subcontractors, and the subcontractors can't enforce the contract. Although the main contractor can enforce the contract for the benefit of their subcontractors, specific performance is a discretionary remedy, and it might not be granted in these kind of circumstances. One way around the situation is to say that the main contractor entered into the contract as a trustee for the subcontractors, but it's often an inadequate kind of remedy. It's important to note that a party to a contract who has not themselves provided consideration will be able to enforce a promise only if they can be regarded as a joint promisee with the person who has provided the consideration. In other words, it's possible to be a party to a contract in which a promise is made but still be a stranger to the consideration. In Trident and General Insurance and McNiece, Mason and Wilson, Chief Justice Mason and Justice Wilson, observed that there can be all sorts of issues in this situation. In particular, there's nothing that the contracting party, the one who hasn't breached, there's nothing that can be done to compel that person to take action against the breaching party to address the concerns of the third party who suffers loss and damage. Obviously, as a lawyer, one of the ways that we can deal with this is to ensure that in the contracts that we write for subcontracting parties or parties who are relying on some external arrangement continuing, that they have a right to compel some sort of activity in the event that there is a breach. One place that you see this quite regularly is in intellectual property transfers and license arrangements, where there will be a promise made or warranty given in the event that there is a breach of the intellectual property that's being transferred or licensed, that the owner or originator of the intellectual property will enforce their contractual and other intellectual property rights against the infringing party for the benefit of and the protection of the party to this contract who's accepting that risk. So the scope basically is pretty broad. It is important to understand that unless you are both a party to the contract and that you have proffered consideration, you are not able to sue under the contract. This does lead to a number of problems, and in the next and final video in this series, I'm going to talk a little bit about circumventing the privity rule. See you then.